The first one here is the Taylor Swift case. Remember, Taylor Swift was appealed. The, what was it, Shake It case got appealed, and Taylor Swift actually loses at this level.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
The case is going to be remanded by the Ninth Circuit Court of Appeals back to the district court for further adjudication. This is only 3 pages. Let's take a quick look here. Sean Hall and Nathan Butler appeal from the district court's dismissal under 12b-6, which means we're on a motion to dismiss in the beginning of the thing. We have not adjudicated the whole thing. This is the beginning of the matter. We're only on appeal because the motion to dismiss was granted. So they appealed the motion to dismiss, or the dismissal, the granting of the motion to dismiss, of their complaint against Taylor Swift, and also Martin Sandberg and Carl Schuster, alleging copyright infringement in the hit song Shake It Off, saying that it illegally copied a 6-word phrase and a 4-part lyrical sequence from Hall's Playas Gonna Play, which was written or produced or published in 2001. They are reviewing de novo, and they reverse and remand. So they're going to tell us ahead of time they reverse and remand. They don't say why yet. That's next. The district court dismissed the complaint based on a lack of originality in the pertinent portions of Hall's work. Remember, copyright only protects original works or portions of works that are original. So the district court, we now know, said that the phrase, the allegedly infringing phrase or infringed phrase, it lacked originality. Quote, any copyrighted expression must be original. Although the amount of creative input required to meet the originality standard is low, it is not negligible. It has to be more than nothing. Noting that originality is established in Vice Publications versus Rural Telecom Services, that was the phone book case. That case noted that originality is established when the work originates in the author and has a spark that goes beyond the banal or trivial. Even taking into account the matters of which the district court took judicial notice, Hall's complaint still plausibly alleged originality. Originality, as we have long recognized, is a question of fact. Quoting the Denzendorf v. 20th Century Fox case from the Ninth Circuit in 1938, that case stated that the question of originality is one of fact, not of law. Justice Holmes long ago cautioned in Blystein versus Donaldson Lithographing Company, I don't even know how to pronounce that word. It would be a dangerous undertaking for persons trained only in law to constitute themselves final judges of the worth of pictorial illustrations outside of the narrowest and most obvious limits. At the one extreme, some works of genius would be sure to miss appreciation. Their very novelty would make them repulsive until the public had learned the new language in which their author spoke. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge, and the taste of any public is not to be treated with contempt. And that's from 1903. Justice Holmes' century-old warning remains valid by concluding that for such short phrases to be protected under the Copyright Act, they must be more creative than the lyrics at issue here. The district court constituted itself as the final judge of the worth of an expressive work because the absence of originality is not established either on the face of the complaint or through the judicially noticed matters. We reverse the district court's dismissal under 12b-6. Swift argues that this court should affirm the district court's decision on other grounds. We decline to do so. The district court may consider Swift's alternative arguments on remand. So what was the district court's dismissal? The district court's dismissal was that the phrase that was used, the allegedly infringing phrase, that was too short or too unoriginal, and so they just outright dismissed it. Now, there was something in here about the actual phrase, right?
I think the phrase was players gonna play and haters gonna hate. That's what Taylor Swift copied, only she repeats players gonna play.
Yeah, you're right.
Play,
It's the players gonna play. Haters gonna hate. And that's what she allegedly ripped off. Now, I don't know. We could look at each other and sort of like go, what? Like, really? That's the thing that she allegedly ripped off? So maybe. So you can see why the judge might have said that lacks originality. Can you really copyright the phrase player's gonna play and hater's gonna hate? Come on, someone has to have used that phrase before 2001 as well. So I'm sure this is all going to come into it, and we're all going to have a very expensive copyright trial if these parties do not settle their claims, their dispute. So let us know what you think of that in the comments below. We might be able to produce that into a short video. That's kind of interesting. Can you really copyright player's gonna play and hater's gonna hate? I don't know. I don't think so. Certainly, there could be evidence. Here's how the law is written. If there was evidence of access to the 2001 work, which there probably is, musicians do listen to music, so courts will often assume that a professional musician does listen to a vast majority of other popular music out there. So the court will probably assume that there's access. And then if there's substantial similarity, now it has to be substantial. It has to be substantial similarity, not just similar, not just similarity, not just some similarity. It has to be substantially similar. If the jury would think it's substantially similar, then Taylor Swift loses. If it should be left to the jury, if it's so unclear as to whether that was copyright infringement that it should be left to the jury to find, then the judge shouldn't be ruling on it as part of a motion to dismiss. That's what that was all about. Thank you for joining us. I am Leonard French, your Lawful Masses host. Thank you very much for your support. We need your financial support on patreon.com/ljfrench and sponsus.com/law in order to keep our mission going, in order to keep paying our people a living wage, if we're even paying them a living wage at this point, but we're getting there. We need your help to get there, so we have to grow, and we're trying to grow. So please feel free to donate to us on Patreon and Sponsus. Thank you to our November $50 plus supporters. Thank you to Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, Blackleaf, Benjamin Hitov, and Steven. And thank you to the $5 plus supporters. We did take some time this morning, and those are the right $5 plus supporters scrolling on the panel behind us, and they will be on the crawl in front of me as I'm saying all of this on the outro of the video. Thank you to Brandon for editing our videos. Thank you to Tactical for your contributions. Thank you to Joe and Kaylee for joining us in the studio today. I am Leonard French, your favorite copyright attorney. I do love you all. Thank you very much for your support. I will see you in the videos that drop. Bye. Bring over some other balls for you. Oh, I hit him in the head. I don't know how many times that has happened. It's a lot.